The war in Ukraine has brought the English legal system into focus. A number of journalists have appeared before parliamentary committees to talk about the lawsuits and legal threats they have faced.
Catherine.
Hi, I'm Catherine Belton, author of Putin's People.
Thank you.
Tom Burgess, I'm on the investigations team at the Financial Times and the author of Kleptopia, How Dirty Money is Conquering the World.
Can you tell us exactly what a strategic lawsuit against public participation is? And what sort of claimants and respondents we get in these cases?
Yes, it's a lot easier to say that you know it when you see it rather than actually giving you a definition. But broadly, it is a lawsuit or a letter before action, any sort of claim that is more about suppressing debate and intimidating a publisher, either from publishing or to try and get them to withdraw publication. More about that than about vindicating reputation and properly securing damages. Who are the claimants and who are the respondents? The claimants tend to be wealthy individuals or companies. The respondents can be anyone from any of the media publishers down to individuals. It's a very broad range of respondents.
We conducted a survey a couple of years ago with 63 journalists in 41 countries, and of those receiving threats, over 70% had received a legal threat, and the UK was identified as the international leading source of those threats. There's a case just settled last week of a Swedish business publication called Realtid that has been sued in the UK. Cases going on for more than 2 years, despite the fact that it is based in Sweden. The journalist is based in Sweden. It's published in Swedish, and the gentleman suing was a Swedish businessman, largely domiciled in Monaco.
One of the journalists spoke about her experience.
Hello, my name's Claire Rucastle-Brown. I am a career journalist. In one example that's now over and done with, where I was dragged into court, I later learnt from the litigant's side that they'd been assured by the law firm, having assessed me, my means, my apparent sort of stamina in this matter, that it should only take an outlay of around £200,000 for the political party that was seeking to undermine my journalism to get me to retract. To force a submission, an apology out of me that would be very useful for them in upcoming elections that were going to be held in Malaysia, where they were siding with the government. That was the subject of the 1MDB scandal. And thanks to marvellous legal support, I'd stood my ground. They retreated because as the politicians involved openly said to their local media, well, the elections are over now. The whole point of it was to put her under pressure during the elections, and we've gained our objective. So that's a slap case.
There is even a case involving sanctions.
In the Yevgeny Prigozhin case, to which the noble Lord Brown of Eton under Hayward referred, he is the founder of the Wagner group of mercenaries currently featuring in the Ukraine. His London solicitors had obtained a dispensation from the United Kingdom Office of Financial Sanctions Implementation to bypass the sanctions that had been made against him in order to fund a personal libel action in the United Kingdom against a journalist, Elliot Higgins. Mr. Higgins worked for Bellingcat, a firm actually based in the Netherlands, where the law is more protective of journalists than here. But of course, the courts of this country are open to all, like the Ritz Hotel. Higgins wrote the truth about Prigozhin's activities, as that leader well knew. He said, when his case was struck out in May of last year, that he brought court cases against journalists because, and I quote, in any issue there should be room for sport. And although the claim was struck out, Mr. Higgins was fastened with costs estimated at £70,000.
Many of the witnesses at these parliamentary hearings spoke about the issues that occur outside the courtroom.
Certainly what Tom and Catherine were saying about the court cases being the tip of the iceberg is very true. So, I mean, what we've seen in our research is that it's the bit that happens sort of unseen in the letters that get sent to journalists who are writing stories. So pre-publication threats, basically, although sometimes afterwards as well.
But, I mean, it's quite well known that some claimant firms send out what they call a legal notice to people, where they hear, I mean, it has no real legal enforcement, but it's on headed paper, it looks very official, and these letters will be distributed to people, warning them that if such and such a story is published, they will get sued. There was a very famous case, in fact, touching on the subject that Oliver touched on earlier, where one of the claimant law firms sent these type of letters to booksellers across England, warning them that if they stocked a particular book, they were going to be sued.
Square. The letters go to your editors, your publishers, your lawyers, and you are cast as the most monstrous, scheming, corrupt version of yourself.
The legal action is never in isolation, in my experience. We have a whole range of service industries here in what's been known as concierge capital of the world.
There's definitely a package. You tend to get the law firm, the PR firm that will do sort of public-facing PR and also what they call black PR, the kind of no fingerprints work, and often a private intelligence firm of sort of former British Special Forces or intelligence or police.
One of my sources, in fact, who I had gone to visit, did get an email with a death threat just hours after I'd visited him. And then shortly after that, his house was under very clear surveillance. I've seen the videotapes. Black PR in all forms. I was hacked. My Gmail was hacked, and a website was set up, which played around with my emails to make it look as if I'd said things I hadn't.
The practicalities of doing journalism, especially since this event, we discovered about those surveillance, the huge lengths you have to go to do sort of counter-surveillance drills you'll be familiar with, that journalists in London have to use. In London.
There are three reasons why this litigation is happening in London. The first is the law, in particular the law of defamation. We have the single meaning rule, which can be a double-edged sword for defendants. Where there is a dispute as to what the words mean, the judge will look at the statement and then decide the single, natural and ordinary meaning of the words a reasonable person would infer. One of the rules in deciding meaning is that the intention of the publisher is irrelevant. Only the publication complained of is admissible. It is also very easy to bring a defamation claim because a claimant only needs to prove four things. The defendant published a statement referring to the claimant, which is defamatory, in that the statement lowers the claimant's reputation in the eyes of right-thinking members of society. The 2013 Defamation Act also requires that the statement has caused or is likely to cause serious harm. Once the claimant proves these four things, there are presumptions which come into effect, such as the claimant is presumed to have a good name, the statement is one of fact, and is also false. To defeat the claim, the defendant either needs to justify it, that is, to prove it true, or use an excuse-type defense, such as honest opinion, privilege, or public interest. According to this excellent book, these presumptions originate in the 18th and 19th century, when the common law was refashioned by the British class system from the perspective of the Victorian gentlemen's clubs of Pall Mall, which were the centre of legal and political life in Britain. Before this, the claimant had to prove that the words were false, published or spoken maliciously, and caused real damage. These presumptions had the effect of reversing the burden of proof onto the defendant. Libel was about determining whether the claimant really was a gentleman. Freedom of expression only had a real legal footing after the passage of the Human Rights Act in the year 2000. The second factor is the legal costs involved with defending a claim.
So it's what makes London attractive for this kind of action?
I think it's the sheer cost of the proceedings here, because as you've seen from my cases, it costs so much to even just reply to a letter from a London law firm.
We've seen research where, even prior to court, it's going to be again about sort of 5, 10, 50,000, even before you get to court, and then it could be up to $1 million.
In our case, I think it's been reported, it costs millions of pounds. A small publishing house wouldn't have that as cash. They withdraw the book and they withdraw it quickly.
We see a lot of journalists who aren't able to take the cases forward or have to settle because they just financially are not in a position to make any other choices at that stage.
And I was actually talking to an academic yesterday who has been subject to a number of slaps, and his university just takes the view that we cannot afford to even begin to try to defend these claims, so we just shut down that speech. We just say, right, that's enough, we're not going to go ahead with publishing whatever that might be, which is the subject of the threat of legal action. So very often you've got really important public interest information that just isn't getting to the surface because these organisations just haven't got the resources to even begin to think about dealing with it.
Then there is a third reason.
It's an issue with the Defamation Act in 2013 was supposed to kind of cramp down on libel tourism, but because London in particular, but the UK, is such a hub for dirty money, and the things that people do with that money, including investment visas, buying property, establishing companies, helps them establish a reputation here, which gives them that link, that reputation that they can then defend through the libel courts. Legal advice is not covered by anti-money laundering regulations, and so if you're buying a house with dirty money, you would go through more checks than you would if you're giving legal advice to a client who wants to potentially sue a journalist.
What you're describing is that if you're rich and you want to intimidate a journalist, the English legal system is the biggest, hardest bat you can pick up and swing.
Yeah.
Is that a shared view?
Yes.
Yeah, Catherine put it really well ahead. It's just really easy to ratchet up costs, which, in the absence of real legal argument, are the actual weapon.
The sad reality, for the most part, is there is nothing new here. Yes, there are other legal claims, such as misuse of private information or data protection, but defamation is a claim most often brought. London is dubiously known by American journalists as a town called Sue. American courts will not enforce UK defamation judgments.
I think it's just instructive to note that Catherine was sued by the oligarchs and oil firms that have already been mentioned in the UK and was not sued by any of them in the US. The law here makes it easier to bring these cases and to ratchet up the costs and take them to a certain level than it does nearly anywhere else in the world.
A decade ago, the UK passed a new Defamation Act which was supposed to address these issues, but it didn't. Really all it did was refine and codify some aspects of the law, but left the law largely as it has been for centuries. The issue is not the defences available, but where the burden of proof lies.
There's also the matter of the main defences, truth and public interest. If you go for public interest, it's really the journalist on trial, not the complainant.
To defend a claim on grounds of public interest, it takes a year or two to defend. The process is unwieldy. It's really burdensome.
Initially, after the invasion of Ukraine, there was talk of changing the law so that claimants had to prove falsity, or even the US actual malice standard, which is proving the defendant knew that it was false, or in reckless disregard of the truth. This was rejected. I don't believe there is a real desire by those in power to change the law in a way that will actually make a difference. The simple reason is that government officials and politicians benefit as much from the current state of English defamation law as do any Russian oligarchs. To be fair, there are some politicians who are trying to introduce anti-SLAPP legislation, such as Bob Seeley, David Davis and Liam Byrne. To truly protect freedom of expression, especially expression in the public interest, the burden of proof needs to be placed back on claimants. In other words, to succeed in a defamation action, the claimant must show on a balance of probabilities that the statement is false. This is a perfectly reasonable proposal, as English law does not entitle a claimant to recover damages for a character that they don't possess. The predictable response from the government is that it's too difficult to prove a negative. This is not so. As Jeffrey Robinson has said, all the claimant has to do is to go into the witness box and aver that the story is false. If he or she survives cross-examination and any defence evidence, their case is proved on a balance of probabilities. There are many instances where claimants need to prove negatives, or even prove falsity, such as malicious falsehood. The claimant also knows the truth, and is usually in a better position to prove falsity than the defendant is to prove truth. As the US Supreme Court recognised, this will insulate some speech that is false, but unprovably so. That landmark decision, which required a plaintiff to prove falsity when the when the speech was of public concern, was decided in 1986, almost 40 years ago. It is perfectly clear that claimants in American courts are able to meet this burden. Second, there also needs to be a quick and inexpensive tribunal that can handle these sorts of claims. There are already tribunals for workplace issues and taxes. Currently, defamation cases can only be brought in the High Court, unless both parties consent, in which case that case can be heard in the county court, which is where most civil claims are heard. I think that would be a more appropriate place for many defamation cases. And third, there should be a legal obligation on lawyers to perform due diligence on their clients, just as any bank is required, especially in cases such as this. Thank you very much for watching this video, and goodbye.